Hi, my name is David Fraser. I'm a privacy and internet lawyer in Canada, and this is my channel, Canadian Privacy Lawyer. In this video, I'm going to do a little bit of an overview of the privacy law landscape in Canada, which can sometimes be described as a mess. In other instances, it can be described as a mosaic. We're not going to get too far into the details, and this should not be treated as advice or legal advice. If you have any particular issues or scenarios that you need advice on, you need to talk to a qualified lawyer in that particular area. Also, this is a pretty complicated area of the law, and so we're just going to be glancing the surface, kind of looking at what laws exist in Canada and what in fact they do. So in the Canadian public sector, the public sector has been subject to privacy laws since the 1980s. And when we talk about the public sector, we're talking about the federal government, the provincial government, municipalities, universities, schools, and hospitals. So first one was the Canadian Privacy Act, the federal statute, which was based on the OECD guidelines. And since then, every single province and territory has a public sector privacy law. One thing that's notable that distinguishes our public sector laws from our private sector laws is our public sector laws are not based on consent. They're based on legitimate purposes that are rooted in lawful sanctioned activities that can allow the collection of personal information for those purposes and the use and disclosure of personal information for those purposes or for compatible purposes. The private sector has been different, quite different since then. And it was only in the 1990s that we began to see any sort of movement whatsoever in this area. Perhaps not surprisingly, Quebec was the first in 1984 to impose regulations on how private sector businesses can collect, use, and disclose personal information. Now, federally, the next move was done by the federal parliament and the federal government, which realized that the European Data Protection Directive was going to potentially impose cross-border restrictions unless Canada came up with a law that met the adequacy standards of that directive. Also, at the same time, the federal government was looking to expand or make Canada on the forefront of the adoption of electronic commerce. And among the things that they realized that they needed to do was to give consumers confidence in how their personal information was going to be collected, used, or disclosed online. So the federal government came up with the Personal Information Protection and Electronic Documents Act. That was passed in the late 1990s. Phase 1 came into effect on January 1, 2001, and it fully came into effect on January 1, 2004. The reason for that phase-in was because provinces also have jurisdiction over privacy. Actually, provinces in Canada have better jurisdiction over privacy because under our constitution, the provincial legislatures have exclusive jurisdiction over property and civil rights. The federal government wanted to come up with a statute, and in order to do that, rooted it in the general trade and commerce power that's included within our federal constitution that reserves that power to the federal parliament. But in order to avoid fights, what they did was that they designed a mechanism so that if a province were to enact a privacy law that was deemed to be substantially similar, the federal government could cede that territory. And that's the reason why PIPEDA, the Personal Information Protection and Electronic Documents Act, only applies to information about employees of federal works undertakings or businesses, and we'll talk about that in a moment, and the collection, use, and disclosure of personal information in the course of commercial activity. It has to be rooted in commercial activity to fit within the general trade and commerce power. But it was also designed so that it would cease to apply in those circumstances where a substantially similar provincial law would apply. And what we saw was that British Columbia, Alberta, and Ontario planned to come up with substantially similar laws during that phase-in period. Ontario did not, but British Columbia and Alberta each passed their Personal Information Protection Acts, and those came into effect at the same time as PIPEDA came fully into effect, which is January 1, 2004. We also have a species of privacy law in Canada dealing with health privacy, health information. And actually, Manitoba was the first Canadian province that came up with its Personal Health Information Act in 1997. And Saskatchewan soon followed suit with its Health Information Protection Act in 1999, and the Alberta Health Information Act came into effect in 2001. Now, none of those laws were designed to be substantially similar to PIPEDA, so you can still have circumstances where the federal law will apply or can apply where that provincial health privacy law does. We did see Ontario was the first to design a health information privacy law that was designed to be substantially similar, so that PIPEDA would cease to apply to physicians in private practice, for example, because they are engaged in commercial activity. You could also think of physiotherapists and other private practitioners, where they would be subject to the federal privacy law for the private sector in their private practices. But as soon as they stepped into a public hospital, they would be subject to a different legal regime. It wasn't a massive problem, but certainly it was enough of a problem that those provinces wanted to intervene. And so Ontario did that with their Personal Health Information Protection Act. And since then, New Brunswick, Nova Scotia, Prince Edward Island, and Newfoundland and Labrador have come up with health information privacy laws. Those last four were designed to be substantially similar, so PIPEDA no longer applies to the practice of medicine, for example, in those provinces. The question often comes up is what laws apply to workplaces to protect information about employees of companies? And public sector workplaces are subject to the provincial and federal public sector privacy statute. So if you're an employee of the federal government, your information is subject to the Privacy Act. If you're an employee of the Ontario government, your information is protected and regulated by the Freedom of Information Protection and Privacy Act in Ontario. But in the private sector, it's a different thing entirely. So the federal government does not have jurisdiction over provincially regulated workplaces. The federal government does have jurisdiction over what are called federal works undertakings or businesses. And so for those organizations, those are airlines, telecommunications companies, things like that. Chartered banks are another example. Then PIPEDA, the federal private sector privacy law, will apply to the information that's collected, used, or disclosed respecting employees, prospective employees, and former employees in those environments. But the federal government can't extend its jurisdiction into provincially regulated workplaces. So if you're an employee of a provincially regulated workplace in every province other than British Columbia, Alberta, and Quebec, you fit into the void. There is, in fact, no regulation of the information that an employer can collect, use, or disclose in those circumstances. But British Columbia, Alberta, and Quebec, with their private sector privacy laws, specifically do apply to workplaces, provincially regulated workplaces in those provinces. We also have another dimension, which is claims for damages for privacy harms. Now, most of our private sector statutes, like PIPEDA and PIPA in British Columbia and Alberta, do have a mechanism by which individuals can recover damages. Those are seldom used. Usually they involve having to go through the complaint process with the privacy commissioner, getting your resolution or getting a conclusion from that process, then commencing a new court action. And they're only designed for individual claims rather than class action claims. Now, the Quebec Civil Code, not surprisingly, provides for redress for privacy harms. And British Columbia, Saskatchewan, Manitoba, and Newfoundland have had statutory torts for invasion of privacy that do allow individuals to recover damages when their personal privacy has been invaded. Those statutes were actually seldom used until relatively recently. What changed was the expansion into common law Canada, so that's most of Canada, the recognition that the common law includes the privacy torts that have been around in the United States for some time, most notably intrusion upon seclusion and public disclosure of private facts. Intrusion upon seclusion, for example, is when an individual intrudes into the privacy or solitude of another person in a manner that would be highly offensive to a reasonable person, and in those cases, damages are presumed. Similarly, public disclosure of private facts, or when somebody discloses private or intimate facts about another in a public manner in a way that would be highly offensive to a reasonable person, and also it's a matter that's not of legitimate concern to the public, designed to protect freedom of the press. And also in that case, privacy harms are assumed, and the damages are going to be determined according to the harm to the individual, which can be general damages, which are generally limited. General damages are to compensate for hurt feelings, the feeling of being intruded upon, creeped out, for example. And those are generally capped at least according to the Ontario Court of Appeal, at $20,000 is the maximum end of those general damages. And pecuniary actual financial harm would not be limited in that sort of way. Although one thing, even though privacy harm is assumed in those cases, the amount of damages that have been awarded by courts has been relatively modest. And that's simply the reality of the way that the Canadian courts have looked at privacy harms. And so what we have here at the end of the day is in Canada, you need to think about, if you're thinking about privacy law at all, which not everybody is, you need to be thinking about, well, what law applies to any particular circumstance? So you have to ask yourself kind of what jurisdiction are you in? And that could be what province or territory are you in? But also, are you in federal jurisdiction? So are you dealing with a bank, a federally regulated bank, or are you dealing with a local business? Then you also need to ask yourself, what sector are we in? Are we in the health sector? And if that province has a health privacy law of its own, and then you need to think about kind of, are you in a workplace? And if you're in a workplace and you're dealing with workplace information, kind of employee information, are you federally regulated? In which case you're subject to PIPEDA, or you could be subject to the public sector statute. Uh, if you're provincially regulated, your information is only protected in British Columbia, Alberta, and Quebec, and the rest of the country is a significant void. So we do have this mess and mosaic. And one thing that makes it even more problematic is that PIPEDA was put in place in order to ensure adequacy with the European Union. So the personal information related to Europeans could be transferred to Canada and vice versa without any particular impediment. It was only PIPEDA that was deemed to be adequate, and PIPEDA doesn't apply to employee information. And therefore, and also PIPEDA doesn't apply in most cases in British Columbia, Alberta, and Quebec. It doesn't apply in the health sector. So we also have a significant gap in our adequacy. And so while I sometimes characterize it as a mosaic, I think we have a number of tiles that are missing that it's actually pretty difficult to address in a federation, particularly where there are a number of provinces that really haven't shown any particular enthusiasm in coming up with privacy regulations. Anyways, I hope that's been informative to let you know kind of what the privacy law and statutory landscape is in Canada. Stay tuned for more, hopefully informational and educational videos on privacy law in Canada. Thanks.